I'm Derek Wilding. I'm co-director of the Centre for Media Transition, and I'm about to speak to Grant Buchanan, who's special counsel to law firm McCarthy Tétrault in Toronto. Grant, thanks very much for joining us this morning. Last week, the online news bill was introduced into the Canadian Parliament, and to some extent it's modelled on the Australian News Media Bargaining Code, but there are some differences. Can you give us an overview of what this bill does and how it differs from the Australian scheme?
Sure, happy to do that, Derek, and thank you for having me. To start with, how the Canadian bill works is our media regulator here is called the CRTC, the Canadian Radio, Television and Telecommunications Commission. They're required to name a digital news intermediary. And if they aren't named, the act doesn't apply to them. But the criteria would definitely apply to Google and Meta here in Canada, and potentially to Twitter. Once named, those organizations, for example, Google and Meta, will continue on with them. They must bargain with eligible news businesses. And this bargaining would ultimately be subject to final offer arbitration, which would be binding. However, Google and Meta can apply to the CRTC to be exempted from being named if they've done certain things. There are criteria that are laid out in the Act. For example, if they have entered into agreements with news businesses and the CRTC is satisfied that those agreements provide fair compensation. If they have ensured that an appropriate portion of that compensation will be used by the news businesses to support news production, and if the agreements cover a significant portion of independent news businesses involving a diversity of news outlets. So you can see what they're trying to do. They're trying to make sure they don't just cherry pick some small outfits. So the test for what is an eligible news business covers almost all Canadian-controlled news publications that have 2 or more news journalists. Broadcast news businesses can also be eligible if they regularly employ 2 or more news journalists as well, if they operate in Canada, and if they produce news content that is not primarily focused on a particular topic like sports or lifestyle. They want more general news. And the CRTC is obligated to register any news business that qualifies. So what happens? The CRTC, for the bargaining process, the CRTC is going to establish a code of conduct that will support fairness and transparency in the negotiations, and also has to maintain a roster of qualified arbitrators. And the bargaining can be triggered by an eligible news business that, or by a group of eligible news businesses, because the Act excludes the use of the Competition Act to prohibit this collective bargaining. So it specifically allows the news entities to bargain as a group.
Right.
Okay, Google and Meta have to have a duty to bargain, and all of the parties have a duty to bargain in good faith. So final arbitration, if it gets to that, so if they aren't first exempt, then they fail to reach a deal, then the mediation fails, and then they get to final arbitration. That will be with 3 arbitrators, and that's only if the bargaining fails. And the CRTC can appoint them if the parties don't agree on the arbitrators who are on the list on the published roster. So the final decision of the arbitrators is binding on the parties. So there's an incentive to sort it out as between them before they get to arbitration. There are also extensive provisions relating to that allow the CRTC to gather information from the platforms and from the news media that it feels it needs to perform its functions under the Act. So the government is concerned with monitoring the impact of the legislation on news, and that's really the whole point, the impact of the legislation in supporting Canadian journalism and Canadian news media. So the bill requires the CRTC to hire an independent auditor to prepare a report annually on the impact of this legislation on the Canadian digital news marketplace. And finally, In terms of enforcement, the CRTC is authorized to impose for contraventions administrative monetary penalties on persons or entities. I don't know if you have the same euphemism in Australia. It's a form of fine without calling it a fine, and it is for companies $10 million for the first offense, $15 million for the second, and recognize that each passing day is considered a new offense. So those can mount up pretty quickly. So let's talk about the differences between Canada and Australia.
Yeah.
You pioneered this, so we had the benefit of seeing what you went through in your country. I'm not an expert on the Australian stuff, but I think there would be half a dozen differences that we could probably agree on. First, in Australia, the determination as to which digital platforms are subject to the Act and whether negotiations have been sufficient to avoid the need for arbitration, that's made by your minister.
Yeah.
In Canada, we are not going that route. These determinations are going to be made by the CRTC and not by the minister. And I don't know whether that's to avoid the criticism of potential political involvement or not, but it's there. The second is that the entitlement of news media to remuneration is much clearer in the Canadian bill. It's described as, in quotes, fair compensation for news content that is made available. In the Australian statute, I understand it's not quite that explicit. Third, in Canada, the agreements must also ensure that an appropriate portion of the remuneration will be used by the news business to produce news content. I'm not sure there's a similar provision in the Australian legislation.
No, there isn't. That's right.
Yeah. Right. Fourth, the Canadian legislation contains explicit exemptions from the application of the Competition Act for collective bargaining by the news outlets. And I thought the Australian law was silent on that point. That may be incorrect, but I'm not sure about that. The Canadian
we have now had some exemptions that allow for that kind of collective negotiation.
Good. Okay. All right. So the next is that the Canadian legislation also gives the CRTC extensive powers to obtain information from the parties and to publish non-confidential information about the effect of the legislation on news media, including having an independent auditor prepare an annual report. And I don't think any of that appears in the Australian legislation. And finally, the Australian law requires the platforms to provide news media with advance notification of planned changes to an algorithm or an internal practice that will have a significant effect on covered news content. We don't have anything like that in the Canadian bill. So that's something that you may consider is better in your bill. But for a guy who doesn't know much about the Australian stuff, that's about as far as I can take.
Yes.
Excuse me.
Yeah, certainly demonstrating a lot of insight into our scheme as well as yours. So thanks, Grant. That's really interesting. Both those similarities. I suppose the starting point in terms of the negotiation, the commercial deals that will operate in preference to the actual mandated bargaining environment. And yeah, like I say, there's a number of similarities, but those differences are interesting as well, including the reporting that you mentioned. But there's several aspects of what you were describing that involve a role of your regulator, the CRTC, and that's quite interesting in terms of the comparison to Australia. And here, of course, it was our cross-sector competition regulator, the ACCC, that was behind our scheme and that had a very strong role right through the process. And I guess it's generally thought that part of the success of this Australian scheme has been the profile of the ACCC and its perseverance, and also that of its former chair, Rod Sims. Our media regulator, the ACMA, doesn't have that same kind of profile, but then it just doesn't have competition powers. So just wondering, what's the how do you think the CRTC sits in that kind of assessment? Is it regarded as a kind of an influential regulator within Canada?
Very definitely, it's an influential regulator, but it's our media regulator. It's primarily broadcasting and telecom. It was not the party that was pushing for this. That came, I think a lot of folks looked jealously at the Australian situation and thought, why can't we do something like that here? So there's been fairly intense lobbying over the last couple of years while that's been going on. And I should mention, by the way, that the platforms have cut deals with the major papers already in anticipation of this. So one of the questions we have is, are those going to get unwound, or what's the impact of the new legislation on existing deals? Because those are all very confidential. So anyway, that's just a side note. The CRTC this is new ground for it. But look, it's had new challenges before. It was only broadcast in 1968. In 1976, it got telecom added to it. Over time, different things have come along. The internet didn't exist then. It finds a way to regulate when asked to by the government and given the proper resources. There are people who think it's over its head on this one, including the former chair of the CRTC itself, who says they should have set up a special new regulatory regime for this and not ask the CRTC to do it. They're not equipped to do it. But if you look at the skills that are going to be needed by this new regulator, they're all available within the CRTC. It's just hasn't been done before. So we will see. I mean, the proof will be in the pudding. But they were not the ones who pushed for it. This is going to get dropped into their lap by the government.
Right. Okay. Very interesting. And so at the moment, we're at the point where the bill has just been introduced. I guess it's got a long way to go yet before there's an outcome on it, or you see some decisive responses from the platforms and other parties.
Yes, that's true. The platforms have not publicly responded. They knew it was coming. It was in the platforms of the parties when they had the election last fall. The bill will pass because it's being supported by enough votes in Parliament of the parties who've already put it in the plan. The question is, what amendments will get made along the way, and how will it shake out? Plus, there's regulations that are required to be made under the Act, and that'll take some time as well. But I don't think there's any doubt that at some point the bill will pass this year.
Okay, right. Great. Grant, thanks very much for that. That's been really, really helpful on a very timely issue. So yeah, thanks very much for joining us.
Well, you're very welcome. Thank you for having me.